Okay. Thank you very much. Our prayer objection. Before I start, my own name is Adidamola Olale Kotulesi. The counsel beside me, his name is Vice Akunle Odesonya. We are part of the legal team. We are more than this. We are not less than 5. But for one reason or another, we are the two responding to your questions and giving press statements as the case may be. Yes, our preliminary objection against the direct criminal complaint filed against our client and one other person at the upper area court in Ilorin came for ruling today. And while the ruling sets aside or overruled our preliminary objection and dismissed same on the ground that the case is not an abuse of court process, we, in our wisdom, applied that the plea of the defendants be taken. In spite of the objection of the prosecutor, the lawyers, the complainant's counsel, so to say, the court, in its infinite wisdom, deemed it fit that their pleas be taken, and they pleaded not guilty. The charge was read to them in English and translated in Yoruba, interpreted in Yoruba, and their plea before the court, in open court, is not an oral application for bail on the ground that same must be formally brought. They must write it down, file it, pay, and serve the other parties. They must do it formally. But the Court of Appeal, on appeal, they overturned it, saying that at the High Court, oral application can be made for the bail of an accused person. And if we look at our administration of criminal justice laws and even the Federal Act, that is the procedure. And as we were continuing, we were allowed to begin with. We asked for the bail orally of the defendants, but the complainants' counsel, their lawyers, they must be more than 20. They objected vehemently, and rather than allow us to finish up with our arguments and the court to rule one way or another, the offenses alleged against our clients being